How did your prior divorce end? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, Washington, D.C., and Chicago, Illinois. In this video, we're going to talk about people who are applying for an immigration benefit, and either the petitioner or the beneficiary, that is the U.S. citizen or the foreign-born spouse, were married before. And we're going to talk about the ways that marriages can end and what the legal effect of those endings are. So, of course, the first one is divorce. And I would say that in my mind, there are two kinds of divorces. There are divorces that happen overseas, and there's divorces that happen in the United States. Now, divorces that happen overseas are subjected to great scrutiny, and that's especially true when the beneficiary, the person who's now here in the United States, married to some other U.S. citizen, gets divorced back home while they're in the United States. The government looks at those divorces very, very closely, and oftentimes they find that the divorces are not in fact valid. This is especially true from divorces from Western Africa in countries such as Nigeria and Ghana. And so we've seen the USCIS and the State Department subject divorces that occur back home when the beneficiary is here and not actively participating in the divorce with a ton of scrutiny. Now, the fact is, there have been lawyers over there in some of those countries preparing fake divorce decrees. And so what that means is that any divorce decree from those countries is subjected to greater scrutiny. But that's especially true for any divorce overseas. I would say that if I were going to file a marriage-based green card now and the beneficiary had some divorce back home, I would probably ask an independent lawyer who is not involved in the divorce to go check the court records and make sure that the divorce was valid. So this is a topic that's coming up a lot in immigration. We're seeing USCIS spend a lot of time looking at prior marriages. And when you get divorced quickly after getting your visit visa, or if you get divorced from here in the United States, you're going to get a lot more scrutiny. A divorce that occurs in the United States is oftentimes given much more weight. They assume that divorces in the 50 states are done under the laws of the United States and of the particular state. And in many of those situations, the foreign-born person files a divorce for their spouse back home. They have to try to serve a copy of the divorce on them so that they can participate if they want to, or they can publish in a legal newspaper the names of the spouse and the fact that they've filed for divorce. A court in America is given great deference, and USCIS believes those marriages are, and those endings of those marriages are much more legitimate when the divorce happens in the United States. So when it comes to divorces, the other thing you always want to think about is the timing of the divorce. When did it happen? Was it right before they got married now to this new U.S. citizen? Was it many, many years ago? Did it happen overseas? Did it happen here? These are the kinds of questions that good immigration lawyers spend their time thinking about when it comes to prior divorces. Now let's talk about when the beneficiary's spouse has died. So they are a widow or a widower. So in that scenario, you're going to have a death certificate. And the visa reciprocity table is a part of the Department of State's website where they have gone through country by country and identified what does a death certificate from that country look like. And so if your prior spouse died overseas, then you're going to have to get a divorce decree there. If they're dying here in the United States, then you would obviously get it from the state in which they live. Death certificates have to be certified and they have to be properly formatted, so the visa reciprocity table will tell you exactly what you need to have in order for your spouse's death certificate to be recognized. And so that's really, really important, because with all of this, what we're trying to establish in any I-130 case is that both people in the couple, the spouses, the U.S. citizen and the foreign national, are both eligible to marry. And so if you were married before, then you have to show that you were divorced or that you are a widow or widower. Those are sort of the main ways that you would show it. Now, there is one other way that marriages can come to an end, and that would be an annulment. So if a court decides that the marriage was void or voidable at the time of marriage, that it wasn't a real marriage, then the marriage can be annulled. Now, getting USCIS or the State Department to pay attention to an actual annulment is very, very difficult. They're very used to seeing divorces. They're very used to seeing death certificates, but annulments are tricky. And sometimes we've seen cases get delayed because USCIS doesn't know what to do with an annulment. And sometimes the annulment is for a marriage that might have made the person's current marriage invalid if the annulment wasn't real. What do I mean by that? Well, let's say you have Mary. Mary was married to Clyde back in the day, and Mary then married Joe, and she did that without a divorce. Well, she could actually go back in time, file for an annulment, and get that prior marriage thrown out. Well, getting USCIS to understand that the marriage to Joe is valid because the marriage to Clyde was annulled is very, very difficult. So annulments are tricky. Annulments mean that it was void at the time that it was entered into, therefore it wasn't valid, therefore courts or USCIS should not recognize it, and therefore there's no need to get a divorce. The annulment serves as the written legal determination that the marriage was never legally valid. And if it was never legally valid, then that means that our beneficiary now is free to marry. So these are the three main ways that you can show that a marriage has ended: divorce, a death of one member of the couple, and annulment. So these are all tricky, especially annulment. And so if you're looking for help filing for a marriage-based green card and you have a prior marriage, give us a call at 314-961-8200 or email us info@hackingimmigrationlaw.com. If you're just looking for free resources, we have those for you. We have our Immigrant Home Facebook group. We have a group of almost 16,000 immigrants in there talking about the immigration process every day. We'd love to have you join us in there. We have our YouTube channel where I post videos like this one 3 or 4 times a week, and we're trying to update you as to recent developments under the law. And we'd love to have you subscribe to the channel and turn on the alerts so that whenever we post a new video, you'll be the first to find out. Also, when we do our Immigration Answers live show, which is a call-in show where you can ask me immigration questions about your situation, we'd love to hear from you there. The number or the way that you would get into the waiting room would be to text the word show to 314-470-3300. We would get you in the waiting room so that you can ask me a question when the show starts. And finally, our last free resource is our Hacking Immigration account on TikTok, and that's @ImmigrationHacking. Thanks so much, and we'll see you next time.